Hello, this is part 5 of State of Wisconsin versus Stephen Avery. We will start where we left off. I will give you a little second to get ready. When we left off, the court was speaking, and we will continue from there. Page 2218. Ready? Let's begin. Attorneys for each side have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact an objection was made by allowing testimony or other evidence to be received over the objection of counsel. The court is not indicating any opinion about the evidence. You jurors are the judges of the credibility of the witnesses and the weight of the evidence. You are not required to, but you may take notes during this trial, except during the opening statements and the closing arguments. The court will provide you with materials for this purpose. In taking notes, you must be careful that it does not distract you from carefully listening and observing the witnesses. You may rely on your notes to refresh your memory during your deliberations. Otherwise, keep them confidential. Your notes will be collected by the juror bailiff after each day's session and kept in a secure place until the next day of trial. After the trial, the notes will be collected and destroyed. You will not have a copy of the written transcript of the trial testimony available for use during your deliberations. You may ask to have specific portions of the testimony read to you. You should pay careful attention to all of the testimony because you must rely primarily on your memory of the evidence and the testimony introduced during trial. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and determine the effect of the evidence as a whole. You are the sole judges of credibility, that is, the believability of the witnesses and of the weight to be given to their testimony. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors: whether the witness has an interest or lack of interest in the result of the trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness recollection, the opportunity the witness had for observing and knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same thing here. To assist you in evaluating the evidence, I will now read to you portions of the specific jury instructions for the offenses with which the defendant is charged. I will read them to you in their entirety at the close of the evidence. Count 1 of the information charges the defendant with first-degree intentional homicide as a party to the crime. Section 939 of the Criminal Code of Wisconsin provides that whoever is concerned in the commission of a crime as a party to that crime may be convicted of that crime, although that person did not directly commit it. The state contends that the defendant was concerned in the commission of the crime of first-degree intentional homicide by either directly committing it or by intentionally aiding and abetting the person who directly committed it. If a person intentionally aids and abets the commission of a crime, then that person is guilty of the crime, as well as the person who directly committed it. A person intentionally aids and abets commission of a crime when acting with knowledge or belief that another person is committing or intends to commit a crime. He knowingly either assists the person who commits the crime or is ready and willing to assist, and the person who commits the crime knows of the willingness to assist. To intentionally aid and abet the crime of first-degree intentional homicide, the defendant must know that another person is committing or intends to commit the crime of first-degree intentional homicide and have the purpose to assist in the commission of that crime. Before you may find the defendant guilty of first-degree intentional homicide as a party to the crime, the state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant directly committed the crime or intentionally aided and abetted the commission of the crime. First-degree intentional homicide, as defined in Section 940.01 of the Criminal Code of Wisconsin, is committed by one who causes the death of another human being with intent to kill that person or another. Before you may find the defendant guilty of first-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. 1. Stephen Avery caused the death of Teresa Halbach or aided and abetted another in causing the death of Teresa Halbach. Cause means that the defendant's act was substantial factor in producing the death. 2. Stephen Avery acted with the intent to kill Teresa Halbach, whether he did so directly or aided and abetted another. Intent to kill means that the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant acted with intent to kill, it does not require that the intent exists for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something.